Good day everyone. In the succeeding videos, we are going to discuss some list of concepts commonly used in conflict of laws. It is my honor to introduce my co-presenter in this video, Mr. Andy Mar Morales, Mr. Andy Glenn Ebueza, Mr. Manny Carl Clarion, Mr. Maronel Jimenez, Mr. Ramon Sumugat, Ms. Cherzelao, and yours truly, Mr. Edmar Perez.
In the study of conflict of laws, we will encounter the concept of foreign element. So what is foreign element? It is anything which is not domestic and has a foreign component to it. So it can be that the party is a foreigner, or the entity involved is a foreign corporation, or the incident happened in a foreign country. Like for example in a labor case, the termination or abuse were committed abroad, or when there is a choice of law, or the foreign law is chosen by the parties, and there is a question whether or not the court should uphold such choice of foreign law.
Jurisdiction comes from the Latin word jus dicere, which means the right to speak is the authority of the tribunal to hear and decide a case. Complete jurisdiction necessarily includes not only the power to enforce any judgment it may render thereon. Recognition of foreign judgment means that our courts will allow said foreign judgment to be presented as a defense to a local litigation. Enforcement, on the other hand, exists when a plaintiff wants the courts to positively carry out and make effective in the Philippines a foreign judgment. In dealing with a problem in conflict of laws, it is important to determine whether the court has jurisdiction over the case. If the court has no jurisdiction, the case should be dismissed on that ground. On the other hand, if the court has jurisdiction, it will determine whether it should assume jurisdiction over the case or dismiss it on the ground of forum nonconvenience. It is the law of the forum that determines whether the court has jurisdiction or not over the case.
Forum nonconvenience. So what is a forum nonconvenience? Forum nonconvenience is a doctrine allowing a court with jurisdiction over a case to dismiss it because of convenience of the parties, and the interest of justice would be better served if the case were brought in a court with proper jurisdiction in another venue. What are the points to be considered in raising forum nonconvenience? Dismissal is not appropriate if an adequate and presently available alternative forum does not exist. If a forum is not presently available, or if the forum provides a remedy so unsatisfactory or inadequate that is tantamount to no remedy at all. The defendant bears the burden of establishing that a presently available and adequate alternative forum exists, and that the balance of private and public interest factors tilts heavily in the favor of the alternative forum.
Of contact. An essential element of conflict of law is the point of contact. Point of contact include place of contracting, or we apply lex loci contractus, place of negotiation of contracts, place of performance, location of subject matter of the contract, the domicile, residence, place of incorporation, nationality, and place of business of parties. And in case of torts and damages, we apply the lex loci delicti comsi, or the law of the place where the tort was committed. And for criminal acts, we apply the locus regit actum, or generally where the criminal act was committed. Point of contact determines the law to be applied in a certain case.
Characterization of conflict of law. What do you understand by the concept of characterization, determining what law to apply in a given conflict problem? Characterization, otherwise known as classification or qualification, is the process of assigning a certain set of facts or factual situation to its proper or correct legal category. These legal categories may be family relations, contracts, torts, succession, property, etc. By characterizing the legal problem, the court or the parties involved reach the proper solution, whether to apply the local law or the proper foreign law. Service of summon in conflict of laws. What is summon? Summon is a writ by which the defendant is notified of the action brought against him. These are the proper service of summon: personal and substituted service, extraterritorial service, non-resident dependent and not found in the Philippines, service of summon or corporation, which is divided into two: domestic corporation and foreign private corporation. Defendant whose identity whereabouts are known by publication in newspaper for general circulation, resident but temporary out of the Philippines with a personal, substituted, or extraterritorial service.
The principle of effectiveness. Judge has no right to pronounce a judgment if it cannot enforce it. In Manila Hotel versus NLRC, it was held that even assuming that a proper decision could be reached by the NLRC, such would not have any binding effect against the employer. Jurisdiction over each person was not acquired. If Santos were an overseas contract worker, Philippine Forum, specifically the POEA, not the NLRC, would protect him. He is not an overseas contract worker, a fact which he admits with conviction.
Theories in the application of foreign laws. Number 1. The theory of comity. Under this theory, we apply the foreign law because of its convenience. And finally, because we want to give protection to our citizens. Number 2. The theory of vested rights. Here, we seek to enforce not the foreign law itself, but the rights that have been vested under such foreign law. Third, the theory of local law. The adherents of this school of thought believe that we apply foreign law not because it is foreign, but because it is our own laws. Fourth, the theory of harmony of laws. The theorists here insist that in many cases, we have to apply the foreign laws so that wherever a case is decided, that is, irrespective of the forum, the solution should be approximately the same. When the goal is realized, there will be a harmony of laws. And last, the theory of justice. The purpose of all laws, including conflict of laws, is the dispensing of justice. If this can be attained in many cases by applying the proper foreign law, we must do so.
And that would be all. I hope you learned a lot about conflict of laws. So thank you for listening. Goodbye.